person, wasn't actually working there. I mean, always best if you can get an actual sign off where the person agrees to it and acknowledges the fact that, they weren't working during those hours. Kind of to piggyback off of something else, kind of what Patrick was talking about there, from the legal risk side of things, one thing that I always try to tell clients is, the reports are obviously fantastic and everything that you can use from a technology perspective to control and get your hands and arms around all of that stuff is wonderful. But the actual, in-person check-ins are things that can't be lost because even when you're trying to get your arms around, the labor cost side of things, a lot of that means, putting parameters, Patrick's point around people working overtime and not clocking in, more than 5 minutes before their start time. But what I see sometimes that creates is then pressure on management to then, want employees to be working before they're clocked in. And that obviously raises other legal issues that makes it difficult to defend from a wage hour perspective because we don't have records of that. We have kind of a he said, she said type of situation there. And one way to certainly kind of try to mitigate that is, doing actual check-ins then from even the higher level management perspective to make sure that type of practice is not occurring. So again, just another kind of tool in the toolbox to make sure from the legal side of things that you're keeping, legal risk mitigated as much as possible.
Yep. And I know, like Patrick was talking about the whole scheduling requirement in California. And I think, it seems like things that started on the West Coast slowly trickle their way to the East Coast. Has there been any momentum with that whole scheduling thing?
Yeah, I will say, I think predictive scheduling, certainly that is an issue. It is primarily been on the West Coast to this point in time. And it's very interesting. I think Oregon is the only state that currently has full predictive scheduling laws in place. Colorado was likely to be next, but it was defeated. But then there are municipalities that have their own predictive scheduling laws. So that's one that we certainly watch very closely. Now, on the flip side of that, there are 10 states, including Ohio, where we are, where the state legislature has proactively passed a law banning municipalities doing their own predictive scheduling laws. So it is definitely one where you definitely see that coastal progressive state and city split versus the more conservative middle of the country.
Okay. And I guess, Patrick, it sounds like you've had to do some of that. Is there any benefit to it, or is it just a burden being added to the operator?
It does. You predominantly mean just getting schedules out a week or two in advance and getting things consistent for our team. I think, ultimately, when it works well, it's good for the restaurant to have a consistent team in place that's doing the same things every day. Obviously, for the employee, often it's beneficial if they know their schedule well in advance so they can plan. I think you go back several years and you could be trying to call employees in that day of work and sending people off, and it was very hard, I think, for the employee to manage that. So I do think there are benefits on both sides, and I think it takes a while getting used to, but I think once it becomes, like most things in the restaurant, commonplace, then it gets easier and easier to manage, and the team gets better and better with it, and it kind of becomes a daily standard versus something new. So yes.
Okay. All right. Let's move to the next question, Cass. So what approaches are successful multi-state operators using to navigate inconsistent labor laws while maintaining fair and compliant HR policies? And I realize that's a very general question, but I guess just kind of what's your general approach to that, Patrick?
Yeah, I'll dive in briefly. It's obviously very challenging. I think to the best of our ability, we try to have uniform policies across all states. Now that sounds great and it sounds storybook. Obviously, it doesn't work when there's different laws in different states. So, again, we had to go to a third-party provider really to provide us the flexibility to manage multiple states, because the brands wouldn't do that for you. At least for the most part, they're not going to create tools and systems to manage, hundreds of different policies and procedures from a city level to a state level to you name it. So theirs are more generic, and we used a third-party provider to try to give us some of that flexibility so we can find out what violations are occurring in California and when, and how we can follow up with those. So overall, obviously the best policy is uniformity across states. It just doesn't always work, and to that ability we just try to manage and educate to the best that we can. We have an HR Tuesday where we send out a newsletter on HR every Tuesday with kind of the different things that are going on. The uniform ones are easy, but then there's individual state changes. So challenging at best, Dustin, but we do the best we can and try to, again, stay standard where we can, and where we can't, we try to educate and manage to the best of our ability.
Okay. Evan, any recommendations for people?
Yeah, well, I mean, just to again piggyback off of what Patrick said there. I mean, I second that. Even from the legal side of things, I mean, one of the most difficult aspects of advising clients on employment law issues is just the patchwork of different states' laws and how that can wildly deviate from state to state. And generally, I fall into the same category as Patrick. I mean, the goal or the best approach, if you can do it, is to try and be as uniform as possible from state to state, both from an HR compliance perspective, because that's less that your HR folks then have to deal with and be aware of from state to state, and then also from an employee relations perspective. A lot of times employees, even from state to state, I mean, if they're actually conscious of the fact that you have an employee handbook and where to access it, they can tell that the policies can deviate from state to state. I mean, if it's spelled out differently among, in your handbook, a lot of restaurants and other, companies that have different facilities from state to state will have a larger handbook that's uniform and then state specific addenda. So there's ways that you can try and shield that, I guess, from employees from state to state, so they're not aware that, the same position in a different state has, different or better, policies or benefits that impact them because state law dictates it. But yeah, I mean, really from a mitigation perspective, it really, I mean, I think it sounds like what Patrick's team does is fantastic. I mean, having weekly or some, some periodic check-ins with your HR folks where you can make sure that they're aware of changes in the law, and it happens all the time. And I think even more so what I tend to see nowadays is, changes at the municipal level. I mean, so even more granular than state by state. I mean, even states where you think you're operating in a state that's what we would say is more employer friendly, you'll have laws that pop up in different, cities or municipalities that, fly under the radar, don't get as much of attention because it only impacts, a subset of people, but you may have a restaurant that's dropped right in the middle of that, so it's something you have to be aware of and really be conscious of, and making sure that your HR folks are, on top of those things.
Yep. And I know sometimes, smaller operators, there may not be a dedicated HR professional. And so, I don't know, I always feel like that's a risk, maybe, I don't know, that I would recommend taking at a restaurant company, that there's somebody that's an HR professional, right. Even if it's part-time or something, somebody that knows and isn't just winging it.
Yeah, and there's a lot of, third-party companies now that will, that you can, even hire somebody or connect with that organization to have somebody part-time that you can connect with to keep you up to, abreast of those things. But even that, I mean, obviously that comes with cost itself. I mean, the best would be obviously if you hire somebody on direct who's dedicated to it. But yeah, I mean, ultimately, definitely from an employment lawyer's perspective, HR folks are, the best thing to have on boots on the ground, kind of keeping abreast of those things and keeping your legal risk mitigated. I mean, both from a cost perspective and I mean, again, a lot of times this stuff doesn't pop up until all of a sudden it does, and it's a huge issue that you just may have been completely unaware of. So yeah, I mean, having a dedicated HR professional is certainly something that if it's in your budget or something that you can move around to have that person hired on, that's definitely a big plus in the legal risk mitigation category.
Okay, all right. I think do we have a CP question next, Kaz? We do. All right, number 2, how are you addressing minimum wage increases operationally the most? So you have to pick one, and again, if you're not an operator, select the last one. Definitely seems like adjusting menu pricing is what everyone is leaning on. I know it's weird with the whole menu pricing. I feel like consumers are just, I won't say numb to it, or they're just expecting it. But certainly, there's a tipping point that, depending on your discretionary income, there's only so many dollars that you plan to spend outside of the home. I know I'm even one, but I just kind of expect things to go up because I know everything else is going up. All right, let's move into some technology. And I know we talked a little bit about some of this, but just talking about with AI, with kiosks, online ordering, labor forecasting, how is that reshaping restaurant labor efficiency? And have we really even, I don't know, do you feel like we've really scratched the surface of it too much, or do you think there's so much more that can be done?
Great question, Dustin. I think AI is so new, and I think it's we're scratching the surface on that level. Having said that, AI still can't tell us how to make a sandwich without tomatoes and that sort of thing. So I do think there's things coming. I think there's a lot of things that brands are working on, so that'll be interesting to see. I do think if you just look at the shift in all of our businesses. We used to be 70% kind of dine in and 30% dine out, and now you flash forward 10 years and post-COVID, and we're like 30% dine in, 70% dine out. So just the industry has really changed, and maybe not for every restaurant, but I know for a lot of fast casual restaurants. So with that comes technology and technology solutions, and the ability to have an order ready when you walk in the door that you just pick off the shelf, to third-party delivery. A lot of our businesses are 15, 20, 25% delivery, just with Uber and DoorDash and all those sorts of things. So with all that, brings the opportunity. The good news, it brings the opportunity to get more efficient on the labor side. If you don't have a cashier anymore, for example, we did put kiosks in all of our restaurants, and all of a sudden, if there's not a cashier involved in the transaction, you save a minute of time. And what do you do with that minute of time times 100 transactions? That adds up to serious hours in a restaurant. So we did look at labor efficiencies. The brand did help us and kind of lead the way in a lot of that. So we did see a lot of labor hour reductions just from technology. Again, some kiosk, but some really... Again, when people are coming in and picking it up off the shelf, you don't have the interaction. You need to have the interaction, but you don't have the interaction at the front counter. Think about now 70% carry out. You're not cleaning tables as much. That's a lot less dishes to wash. There's just a lot of things that you don't really think about that cascade through the restaurant that leads to labor efficiency. So the good news is, it's allowed us to get sharper, and the brand's helped us get more efficient, and we've driven labor out of the cafes because of technology. Everything that you mentioned, from kiosk to online ordering to delivery, to all that has created efficiency to reduce chart hours. The challenge is, now you lose a little bit of guest interaction, you lose a little bit of personality and the ability to impact a guest the way you want to. But overall, I would say the technology has helped a lot and allowed us to get much more efficient in our cafes. And I do think AI is probably just scratching the surface as far as solutions in restaurants. So we'll see how that develops. And again, overall, very exciting. It has helped us a bit. We just got to make sure we can maintain the customer interaction.
Are you finding the average check does increase when using a kiosk or online ordering? With more of the suggestive.
Yeah, surprisingly for us, it does. I think there's a couple things. Obviously we have some desserts in our restaurants, so a lot of times people are a little less likely to order a dessert if they're looking at somebody in the face. But if you're not looking at someone in the face, maybe you get that chocolate chip cookie that you really wanted. So surprisingly, on our kiosk, we do have a higher average check. There are obviously neat things you can do with suggestive selling, and if there's not a drink ordered, a suggested drink, and things like that. So I think things like that you might have to rely on a cashier to do, and sometimes they do, and sometimes they don't. Versus a kiosk that automatically does it, it has driven a slightly higher average check for us, which has been a benefit as well.
Okay. All right, let's move to the next question. How are certain states' labor laws? So we talked about predictive scheduling. I guess on the minimum wage front, Todd, this one's for you. How's those minimum wage laws affecting the industry these days?
Yeah. Thanks, Dustin. So it's fascinating. If you go back 30 or 40 years, most states defaulted to the federal minimum wage, but that has not changed in a large number of years. So if you look at it now, fully 30 states plus Washington, D.C. have a minimum wage higher than the federal minimum wage. And 67 localities have adopted minimum wages that are above their state's minimum wage. Another fascinating thing when you look at it, we are now up to 19 states who have a minimum wage that is indexed for inflation. And we're now down to only 7 states that have, the default to the federal minimum wage. So when you look at that hodgepodge of minimum wages across the country, that certainly is something, especially if you're a multi-state operator, that is a real challenge for you. How do you keep up with all of that? How do you manage your labor costs in that environment? And it's also another interesting, as I was looking at this today, there are going to be fully 24, because you have the 19 that are indexed to inflation, another 6 states that have legislated a minimum wage increase from 24 to 25. So it is constantly going up. And this is something, certainly seems to have started in the coastal progressive states and cities, but obviously if we're at 30 now, it has gone well beyond that as well. And then federally, there has been introduced for the first time by a Republican lawmaker a $15 federal minimum wage. And typically, I would have said that's not likely to pass. But as we start having more majority party legislators from states that have a higher minimum wage, if they start to see that as a competitive disadvantage to states that might have a lower minimum wage, you could see there being some traction toward that at the federal level as well. And then a second thing, Dustin, obviously within certain segments of our industry that have the tipped minimum wage, that's another thing that we have to watch very closely. And there are 7 states that do not have a tipped minimum wage where they pay the full minimum wage. But then when you look at the minimum wage chart, the tipped minimum wage, the difference between the full minimum and the tipped minimum, often referred to as the tip credit, ranges to $1.25 in some of the lower states to up to a $12 difference in some other states. You have seen legislatively and on the ballot a tax on the tipped minimum wage, primarily by One Fair Wage, they've been very successful for a couple of years. There's really been some pushback on that. I think there's been a lot of education by groups like ours that the tipped minimum wage has been very good for a lot of servers, bartenders, other service folks. So you've started to see some pushback and some wins in states maintaining the tipped minimum wage. Again, with the caveat that the servers always make at least the full minimum wage with the tips included, including most recently in Washington, D.C., that it started to phase out the tipped minimum wage. They've actually reversed that now and gone back to having a tipped wage. We talked about predictive scheduling. That is one that it's felt like was really going to gain momentum. And I know Patrick talked about there being some advantages to having some certainty within the scheduling, but some of the predictive scheduling legislation that we saw out there was so onerous. Clearly somebody who operated a business was never a part of the conversation. So because some of those that were pushed were so onerous, I think that's why there's been some pushback against them. Another one I'll just do a brief call out on, another one that varies so much from state to state, is minor labor laws. So if you do employ those younger than 18 in your business, those vary greatly from state to state. And a state law can be more restrictive than the federal law, but if your state has a less restrictive, it defaults to the federal wage. And one, I'll give kudos to the U.S. Department of Labor. There are some handy charts on kind of all of these places where they differ from state to state, where you can go onto their website and you can kind of find a chart or a graph of which states default to which. And so that's something obviously we both call out and we find when we see those things getting more restrictive than operators can possibly deal with.
Great. Let's go to the next question. So there's certainly been a lot of developments, legal developments, with the one big, beautiful bill and with SCOTUS decisions that do have an impact on restaurant labor. So, Evan, can you give us some more about that?
Yeah. So in terms of the one big, beautiful bill, which is still a mouthful to try and say, even the mnemonic is a little bit of a mouthful, but the two kind of biggest aspects of that impact employment law and specifically impact the restaurant industry are obviously the no tax on tips and the no tax on overtime. Now, I think when a lot of people kind of heard those concepts being bandied about, during the election season, I think thought like, wow, where could this go? Kind of what's that going to look like in terms of compensation and how many people are now going to be, all of a sudden clamoring to be, have their compensation largely come in the form of tips. But, when you actually look at the details of the law, now some of it, is kind of more in the wheelhouse of, my tax attorney colleagues. But, there's definitely some limitations on, both the no tax on tips and the no tax on overtime that I think are worthy to be called out. First, and at least on the tip side of things, it's capped at $25,000 a year in terms of the deduction that can be taken, and even that can drop depending on what the earnings of that particular employee are for that year. Obviously, it has to be a qualified tip, so you can't, as the business, just kind of recharacterize something like a surcharge or something. Again, kind of similar concepts that most restaurateurs are aware of that have a tip pool or take a tip credit. You can't have a service charge and then kind of recharacterize that as a tip, and then that be something that an employee can claim a deduction for the no tax on tips. And then the other kind of, again, similar concept to what us as employment lawyers and a lot of restaurateurs are aware of that impacts this is that it can only be for individuals who are engaged in what we call, a customarily and regularly tipped position. So that's kind of one of the biggest limitations. So you can't just all of a sudden, have a position which normally, isn't a customarily and regularly tipped job, and all of a sudden claim that, you're paying this person largely in tips to give them the benefit, of this law. And again, that's a concept that's been, kind of in the law in terms of the Fair Labor Standards Act and how that impacts, the tip credit and tip pools for quite some time. So not an unfamiliar concept, especially to a lot of folks in the restaurant industry. And then in terms of the kind of no tax on overtime, again, it's capped. I think that's capped at $12,500, and again, similar concept. Depending on the employee's earnings, that can even fall from there. And then, kind of another aspect of that I think is something to call out is that it actually has to be something, an overtime payment that is required under the FLSA. So something that has to be over, person has worked over 40 hours and it's time and a half. So, a lot of companies and some restaurants will go above and beyond and actually, pay employees, maybe 2 times if they work, certain shifts or something like that, or work over a certain number of hours in a week. Just because you consider that to be overtime, that extra, if you're going double time, just because you consider that as the restaurant consider that to be overtime doesn't mean that the law is going to give you or give that employee that benefit in terms of the no tax aspect of that. So that's kind of the biggest thing or kind of few biggest things from the recent legislation. In terms of recent SCOTUS developments in kind of the employment law area, the 2 kind of biggest decisions in the last year and a half or 2 years, there was a case about a year and a half ago that really lessened the threshold for what we call adverse employment actions. I mean, so what that is effectively like what happened to the employee, what are they claiming was kind of a discriminatory or wrongful act that would allow them to actually bring a claim in court. And the Supreme Court, really set up the landscape of that, which is, generally their job. And that bar was considerably lowered, at least compared to what it was in a lot of states or a lot of circuits in terms of federal law. For example, in the Sixth Circuit, which includes Michigan, Ohio, Kentucky, and Tennessee, that bar, the law as that had developed was much higher in terms of what an employee was claiming was the adverse action. The Supreme Court sided with some of the other circuits that had a lower bar and said no, it's really something much less than what at least kind of the Sixth Circuit has said. Now, practically speaking, I mean, what's the impact on restaurants or other businesses? It may not be all that much, kind of practically speaking. Now, from the legal side of it, I mean, that gives us, less for us to argue about. I think a lot of what challengers of that, or kind of the other side who are advocating, away from the position that the Supreme Court ultimately took, were, concerned, I think appropriately so, but that it was going to kind of open the floodgates up for an increase in litigation. That's only been about a year and a half or so where that decision's been out there. I frankly haven't seen a huge influx in lawsuits that have been brought, but it definitely has lessened the bar for employees to bring those claims, or former employees to bring those claims. The other big employment law decision that came about was a decision that. So there'd been kind of this standard in the law for what we would call majority plaintiffs. So, for a gender discrimination claim, a male, for a race discrimination claim, a non-minority. And the law in a few circuits used to kind of hold what they would consider a majority plaintiff to kind of a higher evidentiary bar in terms of what they had to prove a discrimination claim, and the Supreme Court effectively did away with that and said, no, it's equal kind of across the board. If you're claiming, gender discrimination or you're claiming race discrimination, there's no higher bar for any particular, plaintiff and a particular protected characteristic. Now, again, practically speaking, what's the impact kind of on your day-to-day operation? Probably not all that much. It was always a claim that was out there that was viable for somebody to bring. And really what the Supreme Court just did with that was basically said, no, it's an equal playing field in terms of what proof is required. So again, more of an impact kind of on what I do and kind of the legal arguments that we would or could make. Probably less of a practical impact, just kind of on day-to-day operations or really even the actual kind of cost of legal spend or legal risk.
Okay. Todd, do you have something to add?
Yeah, so I just want to go back to the One Big Beautiful Bill Act, And on the no tax on tips, just a couple of things to call out for operators who might have some tipped employees, because Evan is correct. You can't just start calling people tipped employees that weren't. But for those who do have traditional, customarily tipped employees, a couple of things from the time this was just a campaign talking point to the time it passed and actually became the law that we worked very hard to make sure were true. Number one, this is a deduction, so it does not lead to any extra work on the part of operators. On your W-2, you already have to report tipped wages separately in a separate box from paid wages. So then when your tipped employee goes to do their taxes at the end of the year, they simply deduct those. So made it sure that it was not overly onerous on operators. And number two, we worked very hard to make sure that, when we say no tax on tips, it certainly only means federal income tax. There was some point of call where that FICA might have gotten involved, and we wanted to make sure that for servers, their ability to get Social Security, Medicare in the future were maintained, and also that income was reported so that when they went to buy a vehicle or, needed credit, that would be included, and also worked very hard to make sure that the 45B FICA tip credit was not at threat. So, and another thing, the operators that I've seen, this is the law, so it will get used. But I would definitely say if you have tipped employees, communicate this as a positive to them. The one thing we should look at as operators is this is another thing that makes jobs in our industry for tipped employees just a little bit better. It also has worked out well for us that the no tax on overtime was done at the same time, because that is something that does more likely to benefit back of house, kind of line cooks as well. So I would make sure you communicate both of those simultaneously to your employees.
Yep, great points. All right, I think we have a CPE question. Which scheduling practices are helping your team avoid unnecessary overtime the most? All right, looks like a lot of the labor forecasting models is number one. All right, next. So I want to make sure we have enough time to talk about immigration. So let's move to question 8. So one more, Kaz. All right. Immigration is in the news everywhere. So, which immigration compliance practices like I-9 audits or E-Verify are most effective in reducing restaurant legal and operational risks? You want to take the lead on that one, Evan?
Yeah. So I can't preach this enough. I mean, the I-9 audit is your best friend. That's going to do the most for you, at least from my perspective and what I've seen and just kind of experienced over the years. Now, obviously, we're definitely seeing an increase in enforcement activity, and kind of I'll touch a little bit on kind of the difference between audits and raids, but definitely an increase in audits. But your internal I-9 audit before ICE comes knocking at your door is definitely going to be your best friend in terms of reducing legal risk. And again, I promise I'm not saying this just to pitch, my colleagues or other legal professionals, but again, to the extent that it's a cost that you can bear, I would also recommend an I-9 audit that is done externally. So you have an immigration or other legal professional come in and do that. And again, even if it's just kind of a spot check, because what we largely see in terms of issues with your I-9 forms is, sometimes it's unfortunate where they just don't exist, and that's obviously a problem. But in terms of just the actual forms themselves, a lot of times it's, mistakes or things that are happening that are, across the board. It's just something that's being missed or just not filled out correctly or that you don't have. So it's happening routinely. So, it's not even necessarily that you have to have an audit that spans, the entire category of all your I-9s. You can do kind of a spot check, and sometimes that'll be, very helpful. But, when the people who are the ones who are tasked with seeing that those things are filled out are also the people who are then auditing them, obviously you can miss a lot. So again, I would recommend that you have some sort of kind of, even if, again, just a third-party company, doesn't necessarily even have to be a legal professional, but someone outside come in and do kind of a spot check audit. Because, again, the penalties can rack up rather quickly, again, if there's issues kind of across the board because you've just been missing something, on all of your I-9 forms. In terms of E-Verify, obviously there's some states that require it, so you have to be aware of it and deal with it. I guess kind of the one piece of that I would add, or kind of, emphasize in terms of, use of E-Verify is just that, make sure whoever you have that's, operating within that system, your employee, that they're trained on it and they actually kind of know what they're doing. Because if you're entering things in there, I think there can be flags that are raised in there that ultimately then kind of increase the potential that you're going to have the government, come and want to do an audit of some sort. So while it can be a very helpful tool in terms of reducing legal risk, if you have somebody who's not trained up on the system, that can have kind of other tangential or other issues that pop up for you. So again, just kind of another training kind of aspect of that you want to make sure to have in place. The person who's operating within that system kind of really knows what they're doing.
Okay. Todd?
Yeah, a couple of things I would add from an operator perspective of that, because Evan is correct. Number one, get your I-9s in order. That is number 1, 2, and 3. But as we are seeing some increased enforcement in both talk about ICE raids and then some actual ICE raids that we've seen within some restaurants, a couple of practical points that I would say to operators. Number one, make sure that you do some training for some folks in your restaurant. Make sure that if they do show up, that your frontline workers know who to go get and tell that somebody is there. And number 2, make sure that person, one of the first things I would say, make sure they understand the difference between a judicial warrant and an administrative warrant. An administrative warrant gives ICE agents a lot less ability to demand things than a judicial warrant. So make sure that you understand that the right person within your understands the difference. And number 3, if this does happen in your restaurant, have a communication plan for how you will deal with it, both with your employees and the public afterward. We have just completed an immigration compliance guide here at the ORHA. Obviously, it's strong for Ohio operators, but I think it could be good for anyone. We've kind of made sure that we kind of write it in plain English. I would still say definitely talk to your immigration attorney if you do start having any issues. But this would be a helpful thing to read to just kind of help you as an operator wrap your head around the sort of things you should be thinking about. And if folks are interested in that, just reach out to me, and it's going to go live on our website within the next couple of days.
Great, Todd. And I know the next question. Sure.
Oh, sorry. I just wanted to kind of jump in on that side of things too. Yeah, Todd's absolutely correct that, training and making sure that your frontline, boots on the ground managers are at the very least aware of, this issue and who to escalate that to. Not necessarily that you need to train them up to the point where they're dealing with it all themselves. In fact, I would recommend that you don't do that. Obviously you want to have upper level managers being involved in that. A couple other things kind of to be just aware of in terms of, things that ICE agents will often do when they appear in terms of an audit. Audits and raids obviously are different. Audits are, they want to see all of your I-9 forms. A raid is different than that, and that a lot of times, arises for completely different reasons than an audit might arise. On the audit side of things, a lot of times, what they're asking for is, copies of your I-9 so they can review those. And by law, you have 3 days to produce those I-9s to them. And a lot of times, along with the audit request, they can and usually have the authority to get other records. not necessarily that you have to produce those within the same 3-day requirement, but a lot of times they will ask for that information too in terms of kind of the administrative subpoena that usually comes with an audit of your I-9s. So again, just to kind of be aware of those different timelines. A lot of times the ICE agents will ask for those things, and not necessarily that they're trying to be malicious or rush you, but I mean, they have a job to do and they'd rather do it, while they're there than have to wait on it. But you don't have to turn that over right away. It's definitely, I think, appropriate. Make sure that that's escalated up to upper management. You ensure that all of the I-9s, because sometimes they don't get placed where they're supposed to be placed. So you have at least a couple of days to work with. It's obviously a very short time frame, but you have a couple of days to work with. And I'd say, take the time that you need to make sure that you're putting your best foot forward when you respond to that. And again, and then in terms of like the other records and stuff that they may request, again, you don't have to rush to necessarily do that within that very much more narrow 3-day time frame.
We did get one question about the I-9. Is there an audit guideline that we could use to review I-9s to make sure we're not making mistakes?
Yeah, I'm sure there is. I'm sure most. I generally loop in my immigration colleagues because it can get a little bit more technical on that compliance side. But I would imagine that there's both ones that you can locate. I don't know if that's something that kind of the industry associations and stuff have any of those. But I-9s are kind of generally touch every business. But yeah, I would guess that the folks at least at my firm here that are on the our immigration group probably have checklists and so forth that you can use that certainly could be helpful. Again, it's maybe a little bit more of a cost-effective way than having somebody come in and do top to bottom audit of every single one of your I-9s. So good question.
Yep. Okay. And our last CPE question, and we're at time. So, which immigration enforcement practice is your restaurant using to stay compliant? So we are right at time, but I wanted to thank Patrick, Evan, and Todd for your time today and sharing your expertise. This will be recorded and made available to everyone. So like Demetra said, there's a follow-up email that will have the recap of everything. So I want to thank everyone for the time. And if you are in driving distance to Columbus, Ohio, we are having a Restaurant Masterclass live event on October 30th. That invite has not gone out yet, but you can save the date right now. So thank you, everyone, and have a good rest of your day. Thanks, everyone.
Thanks.